Good afternoon, everyone, and thank you so much for tuning in and watching our video today. And my name is Hassan Elkhalil, and I am with Elkhalil Law, a law firm based in Atlanta, Georgia. Um, and we are focusing on our practice in immigration and business law. We do a lot of international law. The purpose of this video is to highlight the recent changes to the EB-5 investment visa programs. If you are able to watch us today and be with us today and ask questions, I think that would be great. We will try to answer as many questions as we possibly can. And if you are not able to join us, this video will be available at YouTube. At the end of this session, you will find a lot of information where to find this video if in case you wanted to watch it again and get some information in preparation for filing or getting more information about the EB-5 investment visa program. Also, if you have any questions or if you have any specific questions that we did not answer in this session, as you may know, we will answer only a few questions, or we'll try to answer as many as we possibly can. You can always visit our website at elkhalillaw.com. We have a dedicated page regarding the EB-5 visa. You can ask or you can read there. We have a lot of questions, answers, and or if you need a specific consultation regarding your specific case, you are very welcome to call our office. You may call us via WhatsApp. Our WhatsApp number is 678-900-6845. Again, for further information, how to reach us, you can always go to our website at elkhalillaw.com, and I think you will see our website on the bottom of this page as we conduct this session. Again, I wanted to start this video with highlighting the recent changes of the EB-5 program, as many of you who are concerned or would like to get some information about the EB-5 program. The EB-5 program is a program that allows foreign investors to invest in the United States an amount of either $500,000 or $1 million. This investment allows the foreign investor to come into the United States or to immigrate to the United States with their families, spouse, and children under the age of 21, and of course reside and live legally in the United States. This program has been in place for a long time, since 1990. It was created in 1990s, and since 1990s there are no major changes really. The last major changes was in 1993, and then this program been in place since 1993 under the current rules and regulation. The old requirement for someone to invest in an EB-5 investment or in a program, the EB-5 program, normally you have to invest $1 million. The $1 million you can invest in a project, in a business anywhere in the United States. And based, of course, on this project, you can file your petition for you and your family if this is the case. As also part of the requirement, in addition to the $1 million, you have to create 10 job opportunities for legal permanent residents or for U.S. citizens in the United States. And of course, there are a lot more requirements for this program. The recent changes, and of course, there is the $1 million investment, and there is the $500,000 investment. Someone can invest $500,000, but there are restrictions for the $500,000. If the investor wishes to operate his own business, his or her own business, the investment of the $500,000 must be in a targeted um, uh, employment area. Targeted employment area is in an area that the unemployment is normally 1.5 of the national average. And of course, there are other requirements as well. Um, or the other alternative for the 500,000 requirement is to invest directly in a regional center. If an investor wishes to invest in a regional center, it means that the investor will use the credentials of the regional center. When I say the credentials, it means the financial credentials or the financial statements standing of this project, and also most importantly, the investor does not have to worry about the job creation because the regional center have their own plan on creating the required 10 jobs for your investment. So this, in a nutshell, this is what the old law is. The new law and the new changes, which will take effect on November 21st, 2019. The new changes to the EB-5 program raises the minimum investment from the $1 million to $1.8 million. And this investment, the $1.8 million, it's a direct investment. An investor can invest anywhere in the United States in his own or her own business. And the process will remain the same with the exception, of course, the changes that I wanted to mention later on in this video. The other minimum investment is the $900,000. So the minimum investment was raised from the 500 to 900. And again, this starts November 21st, 2019. Now, the interesting part about this is that you still can invest minimum 900 in a regional center, and the same rules apply. You don't have to worry about creating 10 jobs because you will use the credentials and you will use the financial standings of the regional center, and you will use the job creation that the regional center has already planned for in their plan when they received certification from the USCIS. So this will take place again after November 21st, and then if you decide you wanted to invest directly and you wanted to use only the $900,000 in a targeted employment area or in an area that is designated as the unemployment is time and a half of the national average, the designation of um, the targeted area has changed. Prior or under the current law, we used to use different format in order to classify an area as a targeted unemployment area. Of course, the new regulation makes it a little harder for investor to select areas where he or she can invest the $900,000. And these areas are today will be designated by the USCIS. So we don't really know yet how the USCIS wanted to wanted to make these changes, but according to the recent rules, it says that they will directly designate these areas, and we are, of course, still waiting on how we wanted to file our new applications based on these new rules. So I think this area will be a little skeptical, not clear as far as the designation of the new area for an investor to invest directly in his own business in the amount of $900,000. Of course, and there are more changes, and the fourth point of these changes, of course, the first point that I mentioned is the increase in the amount of the investment. And the second point is the changes to the targeted area. And the third point, there are changes um, to to certain family members, because certain family members may have to file their own separate application if they are not included in the original application in order to remove the conditional residency. And again, this is something new to us. We still did not we didn't do anything. We didn't file any cases based on this new rule. But I think it will. This is just another way for the government to probably make more money. And there's another also the fourth area that is that will take place after November 21st, 2019, is the government or the USCIS will require investors who have like approved EB-5 project to obtain a new priority date uh, or to maintain their priority date. Um, and the government is saying they just wanted to make sure that the investor has more flexibility, or the program has more flexibility. These changes will take effect again on November 21st, 2019. And what we are doing today, we are advising most of our clients or potential clients who has an interest to file for EB-5 visa, or if they have the means, of course, to file for EB-5 visas. I think this is the right time because as some of you know who have been following the EB-5 visa program, or the updates or the law on the EB-5 visa, it's only going to get harder, and it takes time in order to prepare an application. So if there is an interest for someone who is have the intention to file for this type of visa, I think this is the right time. And the sooner you contact your immigration attorney in order to discuss your options and the possibility of applying within the time frame, I think will be a great idea, and it will be the good time to consult with your immigration attorney. On the other hand, if the money is there, it's not an issue. You still can file for the EB-5 visa after the November 21st, 2019 deadline. But of course, the new application after that date, the new rule will apply, of course, the investment amount as well. So again, if there is an interest, this is the right time, and I think many people should, if they have again an interest, should consider consulting with their immigration attorney in order to file the application on time. The From now until November 21st, the current rules and regulation, of course, stays the same, and the program stays the same. You still can apply based on the 500 investment or the $1 million investment, and anyone can, of course, prepare the package and send the application before that deadline. Um, um, we expect, I mean, and again, God knows what will happen. Sometimes we feel that this, we will have a lot more investors. Sometimes we will have a less investors. um, Definitely the interest in this program, I think, will remain high. And definitely the EB-5 investment visa program will attract many more um, a client in the future, from, of course, from different parts of the world. So if you are interested in this program, and if you are serious about it, I think this is the time. And if you think we can help you here at El Khalil Law in answering your questions before you make your decision whether you wanted to move forward or not, you are very welcome to call our office at 770-612-3499. Also, you may visit our website at elkhalillaw.com. Again, you will see it on the bottom of the screen before we finish this video. And Elkhalil Law is spelled as ELKHALILLAW.com. You also can find us on Facebook. Before I leave, I have a few questions I wanted to answer, and most of the questions again are about the EB-5. The first questions we have for this session is, when can I apply for the EB-5 visa? You can apply anytime, but in order for the investor to benefit from the 500 or the $1 million investment, the application must be submitted before November 21st, 2019. My second question is, when should I apply to benefit from the lower investment? Again, it is before November 21st, 2019. The application must be submitted before that day in order for an investor to be able to benefit from the 500 or the $1 million investment. Um, Another question, where should I invest? Um, this is normally, we will leave this up to you. We can help you pretty much narrow your options. If you are, it really depends if on the amount of the investment. It depends on the project that you wanted to invest in, or the business that you wanted to establish. If you want to establish this, if you wanted to run this business yourself, direct investment is one thing. If you wanted to invest in a regional center is another. If you would like to invest in a regional center, at the USCIS website, they have a list of regional centers that are currently available for you to invest in. Of course, we work with few regional centers. We can pretty much send you a list of the regional centers, and then it's your decision to make where do you want it to invest, in which regional center. Um, you probably wanted to consult with your business consultant to determine which regional center meets your requirement, meets your criteria, and have options and conditions for you in a way you are comfortable with and you can live with. Um, and of course, you wanted to make sure that your investment is in the right place, secured, and the regional center, of course, is a good, credible entity, so it will stay and finish the project. And while they are working on a project, you are able to apply and receive your, not only your conditional green card, but your green card for you and if your family is with you on the application. Um, Another question is, if I invest in a regional center, is my investment guaranteed? The law says that the investment must be at risk. I don't think any regional center will give you a guarantee. It's an investment like any other investment. You may make money, you may lose money. Um, it's uh, it's an investment. It's just sometimes you make money, sometimes you don't. It really depends. That's why we highly recommend and we highly encourage our clients to do their due diligence, to investigate, to discuss the numbers of the possible regional center if they are investing in a regional center with their CPA, with their business attorneys or business consultants before they make a decision. Again, because there is no guarantee, and if a regional center or tells or they tell you they shouldn't, I don't know of any really, they shouldn't. But if they tell you that the investment is guaranteed, I think you should walk away. That should be a red flag for you. Um, Another question, can I get my money back? No, you cannot get your money back. It's an investment. Um, it's an investment that like any other investment, you invest in a project and you own shares or you own membership interest in this project. At the end of the process, when I say at the end of the process is when you receive your green card, permanent legal permanent residency for you and your family. If at that time you decide you wanted to sell your shares, you can sell them. You wanted to maintain your shares in the project with the company, you can. You can probably sell them back to the regional center. The regional center may have an option to buy back. They may have the option of first refusal. So it really depends on the agreement between you and the regional center if they will buy back at one point at the market value, or if you have the option to sell it to a third party. But to answer your question, can you get your money back? It's again, it should not be guaranteed. There is no guarantee. You will get your money back if you sell the shares or membership interest that you have in the entity that you invest in the regional center. Um, I have another question here. It says, can I apply for EB-5 if I overstay my visa? In order for someone to be able to apply for EB-5, if this someone or if this investor is in the United States, you have to be in status while you are in the United States. If you are in status, you can apply and of course start the process. If you are outside of the United States, of course you can apply and then you wait until you have the approval. You start the green card, the conditional green card process with the National Visa Center, and then you arrive at the airport and you get your conditional green card at the airport. And if you are in the United States, of course, if you are in status again, you can apply for your application, and then once you receive your conditional green card, you start working. You have the right to work in the United States. This is if you are applying in a regional center, and of course, if you are investing in your own business, you wanted to wait until you have your work authorization before you start working even in your business. So it's I know it's a little bit confusing. On one hand, how do I invest in my business? How do I work in my business if I don't have work authorization? Yet we cannot file your application if you don't invest and you have your business running. So it's a tricky situation. That's why we always, to be on the safe side, we always encourage our clients to apply and hire a manager to run the business until this is one option. Of course, there are many other options until the client has work authorization to work, and then they can work in their business and continue the operation. But to answer the question in short, no, you cannot. If you overstay your visa, you cannot. Um, um, if I overstayed my visa but left the country, can I apply for the EB-5? Yes, if you overstayed and you left the United States, it depends on how long you overstayed your visa. But if you overstayed less than 1 day to 6 months, you have to be outside of the United States for a period of 3 years. If you stay more than 6 months or more than 1 year, you have to stay outside of the United States for a longer period of time. But in either case, this question or the answer to this question depends on case-by-case basis. There's always a waiver. You may be eligible for a waiver. So again, it's a case-by-case basis. If you are in a situation like this, I highly encourage that you consult with your immigration attorney in order to discuss your specifics of your case before you make a determination whether you wanted to apply for the EB-5 or not. I have another question. Can I bring my family with me? Yes, you can. You can bring your wife and your children under the age of 21 or unmarried children under the age of 21. You can include them in your application when you file your initial application. Can I apply for EB-5 if I have a criminal records? This is one of those areas that are very, very sensitive. Again, I refer you back to my previous comment that you have to consult with an immigration attorney in order to investigate and pretty much study or examine your criminal records to see whether you are still eligible to apply for the EB-5 program. From immigration perspective, an applicant has to be very, very careful as to the type of crime and where, because many crimes renders the investor or the applicant ineligible to apply or inadmissible to the United States. That's why we highly recommend that you consult with your immigration attorney to study the specifics of your case and make a determination before you start spending a lot of money on the EB-5 investment package. Another question, when will I be able to apply for citizenship? Normally you can apply for your citizenship when you will count 5 years from the day you receive your conditional green card. So from the day you receive your conditional green card, you count 5 years. 90 days before the 5th anniversary, normally you can send your application. And you can send this application whether you have the permanent green card or not. If you have the conditional green card and then you filed for removal and the removal of your conditional green card is not processed yet, on the 5th anniversary, on the 5th anniversary of your conditional green card, you can file for your citizenship. And again, I think I answered this question. We have a question here. It says, can I apply for EB-5 if I have a prior immigration violations? Again, it really depends. In general, no, but it depends on your specific circumstances. It depends on your specific situation and the type of violations, the length of the violations. And again, this is one of those areas that we cannot offer a specific answer. I think you should consult with your immigration attorney regarding your specific situation. I think you will be best served in this case if you consult with your immigration attorney regarding the specifics of your case. A few more questions I wanted to take here. It says here, the question is, if I already have a business in the US, can I use this business to apply for the EB-5? Yes, but it really depends on how and when you established the business. Was it established business? How long you've been in business? Where did the money come from? And because as part, whether it's under the current rule or the new rules, we have to document very in a tedious and very detailed way the sources of the fund. The sources of the fund is very important area or supporting documents as part of the application. So we have to document where the funds came from, and then of course the way you acquired the business, how long, how is the business doing. There may be a possibility, but again, This is very specific. It depends on the specifics of your case. And if indeed this is the case in your case, and the person who was asking this question, I highly recommend that you consult with your immigration attorney, and that so you can determine the which course of action best suits your specific facts. If you notice that I am referring many times to consult with your immigration attorneys, because immigration law is a very complicated area of the law, and it's very a complex area of the law. And that's why, unfortunately, sometimes when we give an answer, it's only for for general information, for educational purposes, but it is not to be taking, whether in this video or other videos, or in this statement or other statements, it is only for educational purposes only, and we are answering in general. We do not, of course, this video or these statements in this video should not be construed to be a legal advice, only because, again, cases are different, individuals are different, families are different, businesses are different. Each investor, each client, each business are distinct, and they have their own characteristics. So that's why it's very, very important, before you decide you wanted to start this process, to set an appointment with an immigration attorney, so you can go into a lot of details. As you probably will notice, a consultation with immigration attorney, it takes sometimes 2-3 hours to go over your background, your financial background, criminal background, immigration background, educational background, business background. So there are so many things that we really need to know before we answer sometimes one simple questions, or sometimes one just straightforward questions. If it is straightforward for you, a simple question for you, it may not be for another client, for another person. That's why we highly encourage that you consult with an immigration attorney for the specifics of your case and for the specifics of your question. Moving forward, I have a question, says, how can I prove the funds are mine? Again, this is very, very important part of the application. We have to prove the sources of the fund. We normally in our office, we have what we call a funds report. It's pretty much a separate package from the application that we prepare to include in the application, because we document a very, very very much in details the sources of the fund, where they came from, how long you had them, whether the funds are taxed or not, the source of the fund, whether you sold a piece of property in your homeland, or you sold a business, or you inherited the money. We have to document the sources of the fund, and then we have to follow the chain of possession of the fund. Of course, you can receive a gift sometimes, but we wanted to know who is giving the gift, and the reason sometimes. But to answer your question, there are many ways for us to find out or to prove that the money is yours, through your bank accounts, through your investment in the business or business account, or the sale of property, or sale of shares, or any others. Forgive me. I have a question here. It says, what is the liability for EB-5 investor? The tax liability for EB-5 investment or investor. What is the tax liability for EB-5 investor? The tax liability, I mean, the question is not really clear, but the tax liability, I'm hoping that this person is, or I'm assuming the tax liability when someone moves into the United States. I wanted to defer this question for a CPA to answer because this is outside of the area of our expertise. But in general, yes, there are tax liabilities for a legal permanent resident and or U.S. citizen. We have tax system and we pay taxes on the income generated from anywhere around the world. And if an investor, for instance, in this case, if an investor invests $1 million in the United States, but this investor still has some investment outside of the United States. If this investor makes, let's say, on his investment in the United States, $50,000 a year, but makes $3 million income outside of the United States, if the investor is a conditional permanent resident or legal permanent resident, this investor, according to US laws today, must disclose and pay taxes for income generated anywhere around the world. In the example I just gave, the potential investor will have to pay taxes on the 3 million that he made outside of the United States, in addition to the 50,000 that he made in the United States. In addition to the income tax that the investor must pay when he or she receives the temporary green card or permanent green card. As soon as they immigrate to the United States, there are certain rules that they need to follow in order to file their first filing and probably disclose their assets outside of the United States. And again, this is general, but I think you should consult with a CPA. I think CPA will advise you better on what you need to do as a new immigrant to the United States. One last question I have here, it says, if I invest in a regional center, do I have to work in a regional center? No, you don't have to work, and this is the advantage of investing in a regional center. And this is pretty much one of the distinctions between investing in a regional center and or operating your own business, direct versus indirect investment. If you invest in a regional center, you do not have to, one, work in the regional center, two, cannot be concerned or worried about creating the 10 employment. And these are, to some investors, are very, very good concerns that they don't want to worry about them. But if you have a direct investment, if you invest if you have direct investment, if you establish your own business, yes, you have to work in your business once you have the work authorization, and then your employment in your own business will not be counted against the 10 jobs that you have to create for US citizens or legal permanent residents. I hope I answered this question clearly for you. And this is pretty much the end of our session, where we will not be taking any more questions because we're running out of time. But what I wanted to leave you with, I wanted to recap. Sorry, I wanted to recap what we stated in this video. The major changes that there in the new law are the increase in the investment amount. The amount went up from 500 to 900, and then from 1 million to 1.8. And the second point is the targeted area. The designation of the targeted area changed. It's more, I think it's more restrictive. And the third, the procedure to remove conditional residency changed. Certain family members are required to file separate applications to remove the conditional residency. And then the last point is retaining the priority date if someone has previously approved the EB-5 project. So these are mainly the changes in the new law. And these changes, again, this is very important for a potential investor to be aware of. These changes take effect only on November 21st, 2019. So after November 21st, 2019, these changes will apply. You can no longer use the 500 to apply for EB-5 investment visa. Because of the short period of time left for many investors to benefit from the 500, uh, again, we highly encourage um, the potential investors or individuals who has the intention to apply, or if they are thinking about applying for EB-5 investor visa, this is the right time. I cannot stress enough on the fact that to contact your immigration attorney and discuss your options, because there is still some time for a possible investor to prepare an application and mail it before the deadline. If you think, again, before I tell you this, this video will be available on YouTube. You can watch it again if you wish to, and you can pretty much answer, listen to the questions. If you have a question about the EB-5 visa, you can always visit our website at elkhalillaw.com. The address will be on the bottom of the screen, and we have dedicated page for the EB-5 program. If we don't have an answer to your question, you are very welcome to contact our office. Our office phone number is 770-612-3499, or you may reach us via WhatsApp at 678-900-6845. Of course, you are welcome to follow us on Facebook, Twitter, or social media. And we normally have many postings related to the EB-5 visa and other immigration and business topics here in the United States. I hope this video was helpful, and I hope to see you, and we are looking forward to be of service, and we are looking forward to be part of your American dream. Thank you so much for your time watching this video, and again, we're looking forward to be part of your American dream. Thank you, and you have a wonderful afternoon.